アジアバイアウトシンポジウムをご視聴くださいましてありがとうございます。JASRAC 組織本部の渡辺と申します。本日の進行役を務めさせていただきます。シンポジウムは英語で行われます。日本語通訳音声は画面の音声を切り替えていただきますか、日本語 URL を選んでご視聴ください。それでは英語で進行させていただきます。Welcome to JASRAC and APMA jointly organized Asian Copyright Buyout Symposium. I'm Satoshi Watanabe, Senior Administrator of JASRAC, and I'm doing the Secretariat work for APMA or APMA. I will be MC of the symposium today. And now, Ms. Manami Suko, an Executive Director of JASRAC, co-organizer of the program, will make an opening remark. Suko-san,
hello, everyone. I am Suko Manami. The Japanese Society for Rights of Authors, Composers, and Publishers, JASRAC, is excited to co-organize the Asian Buyout Symposium with the Asia Pacific Music Creators Alliance, APMA. JASRAC established in 1939 as the only collective management organization in Japan whose member music creators and publishers participate directly in its governance, is highly concerned with matters that affect its members. For over 20 years, JASRAC has organized symposiums on many different topics, focusing on how authors' rights can and should be protected as the world around us continues to evolve. APMA, formed by music creators and for music creators in 2016, continues to bring together the voices of music creators from around the region on issues such as fair compensation for creators in the digital age and copyright term extension in the region. JASRAC is happy to join APMA in the effort to educate music creators on the issue of buyouts and long-term effects it may have on their livelihoods. We inform the audience that due to unavoidable circumstances, Mr. Tokura Shunichi, who will take part in the opening segment, will not be able to stay with us for the panel discussion, the final segment of this symposium. We thank the participants for this contribution to this symposium co-organized by JASRAC and APMA, and look forward to a lively discussion. Thank you.
Thank you. So the first session is a talk between two music creators, Shunichi Tokura and Björn Ulvaeus. Björn, please turn on your camera now. Thank you very much.
Here we are.
Okay, it is my great honor and a pleasure to start the first session with two very distinguished music creators. Mr. Shunichi Tokura is a Japanese composer, arranger, producer, and he is chairman of APMA. And Mr. Björn Ulvaeus is a Swedish songwriter, musician, singer, guitarist, producer, and a member of the Swedish musical group ABBA. He is president of CISAC, the International Confederation of Societies of Authors and Composers, which is a global network of 230 member authors societies in 121 countries. That's CISAC. So, Mr. Tokura, would you start the talk session?
Thank you, Satoshi. And Björn, good morning to you.
Good morning to you, or good evening to you.
Yes, good evening here. Firstly, I'd like to congratulate you that you took over the presidency of CISAC in this hard time during this pandemic. And I believe that I'm one of the many followers of yours and your contribution, your creation, and your activities throughout the years. And we were very happy that you took this role as a president of CISAC. So how are you keeping it up during this pandemic as a president of CISAC to start with?
Well, obviously I was asked to become president before the pandemic. So I had already accepted.
Okay.
It took a while. I had to think long and hard whether I could be president of anything. But in the end, I decided, yeah, maybe I can do something, you know, with my experience and my background, something that could be valuable to CISAC. So I decided to accept.
Sure.
And during this time, it's been very interesting. I've had many Zoom meetings. I meet weekly with Gadi Oron, who is the CEO of CISAC, of course. And my primary reason of becoming president was that I have a vision of the global solution to this fragmentation of rights and data that is happening because of the digital era and the streaming services. They're all cloud-based, and the CMO infrastructure wasn't quite ready for, I think, the onslaught of the streaming services. So that's one of my greatest concerns, is for the CMOs to keep up technologically.
Okay. So you are you're now in Sweden, right?
I am in Sweden right now.
And do you have any opportunity to visit CISAC in Paris?
Not yet, sadly.
Oh, really? Okay.
Yeah. I've been wanting to go down there and meet all the people, but the pandemic held me back.
Yeah, but there's so many, modern tools that we can communicate with each other, and that's one of the subjects that we want to get into. But before that, it's inevitable that we will start with this tonight with this COVID-19 situation. And the entire entertainment industry is not only suffering financially, but overshadowed by discouragement, lack of hope, despair, whatever you want to call it. And we have found ways to communicate through various medias and to transmit our music. But I'm sure many people will agree that for me, music is all about human contact and communications. And to lack that, takes away something very important from us. But having said that, we do have various modern tools that we utilize in our daily life, which help us during this pandemic. And that goes for our musical activities as well. Our life, our activities, even our musical creation is so dependent on these digital modern tools. What I wanted to ask you, if you can describe to us how your activities have changed, and for that matter, your environment and your thoughts of maybe, it goes maybe to the musical consumption of people, in this digital era. And sometimes it's very convenient, sometimes we lose something through that. What do you think about that?
I think we've come to realize that at a concert, I think, almost 50% of the experience is to be in an audience, and the contact between the performer and the audience is something that cannot be substituted with Zoom. It's absolutely impossible.
Absolutely.
And I have several theaters in Stockholm. And of course, I have musicals running that were running before in London and many other places, and everything is closed down, and that it's very sad. You know, the artists used to make 70% of their income. About 70% of their income was from live entertainment, from live gigs. And now they suddenly found that, you know, they are in the same position as the songwriters have always been, you know, that they earn too little money, and which has put the focus, I think, on the songwriter more than ever, because this business of ours has never been more centered on the song than it is right now. The song is everything. I mean, I have grandchildren who listen to music on Spotify, and they listen to songs. They don't even know who the artist is.
No.
And it's amazing then that the songwriter should be in the periphery, always the poor cousin to the recording in our world. And I think this could be the year of the song. I hope sincerely it will be. When you know, when the streaming services may look at the song as important as it is.
Okay. Absolutely. This environment that we live in is so strange, and especially with this COVID, things are really rapidly changing people's mind, as well as you know, not only performance but for creation as well. Did it change your? I mean, obviously you're still creating many music at home. You know, what has it changed your ways of doing music?
It hasn't really, because Benny Andersson and I, we can still meet, you know, at his or my place, because it's big and airy, and we can keep the distance, and so I've always written with him, so it hasn't changed for me, but I'm sure that it has changed for so many millions of songwriters around the globe. I find that meetings like this, like or meetings about economy, about whatever, can take place via Zoom, but creative meetings, then you need to be able to see, to be able to reply immediately. You need to see people's reactions in a different way. So I'm missing that.
Yes.
I'm right in the middle of a project where with digital copies of ABBA, who are going to be performing as avatars in London in a purpose-built arena. And that is a lot of creative work around that, which now has to be through Zoom. But I mean, what can you do? There's nothing else you can do.
Absolutely. Now, today's topic, as many of you have seen in the invitation, is copyright buyout. Buyout has its history from very early days in the music industry, when copyright awareness was still very immature. And here in Japan, you know, buyout was not a common practice, but it was there in the 60s and the 70s, especially when it comes to, for example, advertisement, jingles, theme music for television, motion picture. I myself had multiple buyout experiences on TV commercials, etc. And I thought in those days, in the 60s and the 70s, I thought it was paid pretty handsomely and I had no complaints. But Björn, I think you agree that nowadays, when there's so many ways musical creation is utilized in vast quantities and generates a huge amount of remuneration, creators should be aware of the nature of their rights. So can you share with me maybe your experience in your early career, that, you know, something similar to this situation I just explained was part of your in your world?
Yeah, well, I suppose I was lucky. I started writing in the latter half of the 60s, 1960s.
Okay.
And even back then, there was never any talk of buyout in Sweden, and it simply didn't happen. I didn't know about it even. It was, you know, you wrote a song and you got registered with STIM, which is the CMO of Sweden, and you got your royalties. So I was very lucky, but emotionally, I tried to put myself in the shoes of someone who has parted with his rights completely of a song that then becomes, you know, something which is lasting maybe, and which is being played. It would be terrible to be in that situation. Did you ever, was there ever any buyout of your material that still is played now, and do you regret it?
I hear, sometimes I hear a little jingle for about 3.5 seconds, something like that, and said, hey, that rings a bell, maybe 40 years ago, you know. But in those days, it was like, you know, I was doing it for fun, and I wanted to, you know, it was great to have a work, you know, whatever it was, in my early 20s, for example. So, you know, but I still, you know, hear all these little sounds, or even the little arrangements that I did, that is still, you know, because when the company grew and it grew to be a big, huge company with a tradition, you know, with all these huge capacity of their marketing and all that, and you know, people are so used to these kind of little catchphrase, if you like, of these companies, and they still use it. So and I, to be quite honest, strangely, I never made a fuss about it.
No. But if it had been a whole song, and a song that would have lived through decades, then you might have been a bit more disappointed.
Exactly.
But I think, with my experience, the only thing I can say to young songwriters is, or they need to be educated. They need to absolutely be advised in the matter of what it could mean to them.
Absolutely.
If they go for a buyout. Because I think in the end, if you do it with a song that you've written with your heart, and which is dear to you, and which you think is a really good song, then to let people buy it out completely could be very tragic, very, very sad. And I think that's the most important point.
Exactly.
Don't do it. If you really love that song, absolutely do not let them buy it out.
Exactly. Well, when we talk about buyouts, and what we want to focus is the problematic buyouts, which I call it like subjugated buyout, for example. That is when a party with a dominant preponderance force a deal with the young creator who cannot repudiate. So if you want to say no, you got to really know, and exactly like you say, if you want to say no, you have to have a knowledge of what your rights are. And without that, you know, like I told you earlier, when you're a young songwriter, you're so happy to have your song published or broadcast or, you know, streamed or whatever. and you'll do everything for it, just have your name on it. But remuneration is a different issue, and it takes time for a young creator to learn that. And so exactly like you say, education, yes, education is the name of the word, isn't it?
Yeah. And I think also the lawmaker must help. There must be rules. It almost like you have to read the young songwriter, the Miranda rights, have you asked an advisor, have you done this or that before you take this decision? That would be a good thing if a document signed for a buyout must be preceded by making sure that the writer knows exactly what he's doing.
Yes. Okay. APMA has, we're trying to develop some kind of an educational system, seminar, for example, etc. Because in Asian Pacific region, there are still many cases that we discuss in our executive committee or in their General Assembly. It's unlike North America or in Europe. It's still, there's so many underdeveloping countries, but there are brilliant minds, talents in the Southeast. We have, APMA has 21 members now. We started in 2016 with 8 countries. Now it's 21 countries. The last country who joined us was Nepal. And the Nepalese young composer who came to Tokyo with JASRAC's invitation just, introduced us a lot of cases that they were practically ripped off. A very renowned composer from Thailand, his name was Tanit Chernopipat. He's one of the board member of APMA, and he's a well-known composer today. But and he's a performer as well. And last time when he introduced us with his episode, it was like he had to pay an amount of money just to perform his own songs.
Yeah.
I thought that was
absurd. It's absurd.
And so it really is the situation. So in Asian Pacific region, especially APMA is working pretty hard to educate these young creators.
I suppose that could be a kind of compromise, because to work for hire could be a way for a young composer to get going. But then the buyout shouldn't be for more than, say, 10 years, and then the rights should revert.
Yes,
that is also a solution, because for a young writer to get royalties to start flowing in, he needs a body of work. And maybe to start him off, it's good to work for hire for a while.
Exactly. Yes. I think it depends on the region, depends on the market. But I totally agree that we need help of CISAC, for example, an international operation, and to focus on these areas in the world globally, focus globally on which areas that these education, their efforts must be focused on. And I think Asia Pacific region need all the help we can get. So, we have to, our time is, yes, Satoshi has been staring at me. But, lastly, I want for you to explain or to tell us how you feel about, do you feel there's going to be a huge change in the music world after this pandemic, post COVID-19, as far as creations, consumption, marketing, whatever, because this has changed our life so drastically.
It has, and the use of music, the listening has gone up, and music is more important to people than ever, I think. It's just that the music industry the ecosystem is dysfunctional, because it doesn't reward those who are in the middle enough. And I'm talking about the songwriters primarily. Those who are the most important to the business are in the periphery when it comes to payments. And that has to change, obviously. And the solutions, what are they? Well, as it is right now, 4 times, the labels are getting paid 4 times as much as the publishers by the DSPs. That's an imbalance that has to be addressed. And I think the CMOs need to be more effective.
Okay.
They need to step up their technology, and they need global solutions, cloud-based global solutions. I think that it's a shame that the GRD, the global repertoire database, was shut down because it's not in the interest of the songwriters for the CMOs to compete with database. The CMOs should compete with their service to the songwriter. And they should ask themselves, whenever they do something, is this in the interest of our songwriters or not? And sometimes I think that the CMOs look at themselves as entities that are competing, and I think that's completely wrong. Okay. I think we need to look for third-party solutions, global solutions to the problem of inaccurate metadata.
Okay. So I think we can conclude this, that, whatever we do, however we do it, we will talk with JASRAC in the coming days, post-COVID-19, obviously. But, I think the key word, Olympic game is coming, and everything was so in a turmoil this past 6 months. And luckily, we seem to be, the Torch Marathon has started today.
Yeah.
And so I'm crossing my fingers that the Olympic Games would be successful this summer here. But during all these difficulties, the key word was athletes first. That was the key word of the Olympic Committee. Okay, but I'm telling, if athlete first, in the music world, why not somebody says creators first? Yeah, artists, right? I mean, that might be the key word for our.
That is certainly a good keyword,
isn't it?
Yes.
So Satoshi, is it the time is out now? Yeah. So we thank Björn for joining us tonight, and it was lovely talking to you. And I hope to meet you in person in the near future.
Yes, absolutely. And I hope you have a good good seminar going forward with the buyouts. It's a very, very important issue. And I'm glad that you're taking time discussing it.
Thank you. Thank you, Björn.
Thank you.
And that's for now, right? Bye. Bye, everybody. Thank you, Satoshi-san.
Thank you very much. It's very interesting dialogue between 2 big music creators. They share their personal experience in their early day of careers, including the buyout issues and post-COVID situation. It's quite wonderful and interesting talk. Thank you very much again. Okay, so the next session is Professor Lee's presentation about her buyout study in the Asia Pacific region. So I'd like to invite Professor Lee now, and she is an associate professor of law at the University of Hong Kong, specializing in intellectual property law and IP education. To the audience, if you have a question and the comments, please write in the chat box, and we will discuss the questions at the later session. So now, Professor Lee, floor is yours, please.
Thank you very much, Mr. Watanabe. So now I'm going to share my screen.
Yes.
And I hope you can all see it now.
Yes, I can see.
Thank you very much.
Yeah.
So I will try to keep the time and do it within 30 minutes because we will have question and answers afterwards.
Sure.
So this is the topic. This has been my study for the past 2 years. This is on copyright buyout in Asia Pacific region. And before I start, perhaps I will tell everyone these are the 6 points that I'm going to talk about today. So the first point is what is copyright buyout? And secondly, what are the objectives of this study? Number 3, the scope of the study in terms of the geographical scope and also the industries that we have been investigating. And then number 4, I will be sharing the survey questions that we have been distributing to different members of CISAC in the Asia Pacific region. And then number 5, I will be mentioning 5 recommendations. And finally, we will look at the way forward. That would be our second stage of the study. So if I may begin with the first topic, that is copyright buyout. So what exactly is copyright buyout then? This is a very simple definition. I have tried to present the definition in the form of these symbols. We start from the left and the top 3 parties, as you could see on the slide. We are talking about a record company or a film producer or online video streaming service provider or a video game producer. What do these parties do? And then the second row, these parties, they will commission the creation of a musical work. And here I use the word commission to mean that they are buying all the copyright from the creator in return for just the sum of money. So in other words, they are not paying royalties. Royalties are different from this buyout situation. The main difference is, as you can see at the very end of this slide, the creator cannot use the work later. That is because buyout means the record company, the film producer, or the game producer, they are buying all the copyright. They just pay one lump sum to the creator, after which the creator cannot use the copyright anymore. So is this a good thing or a bad thing? We want to know more. And so that is why we have APMA, the Asia Pacific Music Creators Alliance, as well as CISAC, the International Confederation of Societies of Authors and Composers. Together, they believe that this is an important topic for all creators in every part of the world. And so that is why they invited me to do this Asia Pacific comparative study of the buyout practices in different CISAC members and APMA members. And today we also have JASRAC hosting this symposium to actually see what we can do to do 2 things. So we have 2 objectives. Number 1, we want to empower all the creators, authors, and composers. How do we empower them? We give them the knowledge that they need in order to negotiate with the record company or the film producer. That is our first objective. And the second objective is to raise awareness of copyright buyout issues. In particular, we wanted to talk to government, and also we want to promote this as a public education program. And that is why we are very excited to see the initiative, Your Music, Your Future. which we will talk more about in the subsequent Q&A session. So these are our two objectives: to empower the creators as well as to promote awareness among government bodies as well as the members of the public. Now, the scope of this study. So what are the industries we're talking about in terms of copyright buyout? Mainly, we are talking about music industry because we are talking about musical works that are being used. But used for what purposes? Then they're being used in related industries that are listed on the right, namely the film industry, the broadcasting industry, or the video game industry. So we are talking about all these industries where you will have musical works being created on a daily basis. And we want to help those creators get the rights, protection, and the remuneration that they deserve. As to the geographical scope of our comparative study, these are the 8 territories that we have surveyed in phase 1 of the study. They are in alphabetical order: Australia, Hong Kong, Indonesia, Japan, Macau, South Korea, Thailand, and Vietnam. And of course, we have also surveyed other territories in Asia Pacific, and they will be covered in phase 2 of this study. What questions do we ask then? We actually come up with these 7 questions with the guidance of APMA and also CISAC. So we have some brainstorming discussion with Ben from CISAC and also Mr. Tokura from APMA and also Mr. Watanabe from JASRAC. So we have come up with these questions we think would be the most important questions. Maybe I will go over them one by one before we look at the survey results. Number 1, the first question is about copyright law in the different territories. The question we asked was whether creators can give up or waive their moral rights. I use the word waive here in quotation marks because this may be a technical legal word, but in simple language, the word waive simply means to give up. That means you don't want your right, you surrender your right. And I have underlined moral rights here because actually moral rights are related to copyright, but they're not exactly the same. So later on, I will talk more about the difference between copyright on the one hand and moral rights on the other hand. We think this is one important question. So this is question number 1. Question number 2 is not about copyright. It is about contract law. And that is because we understand that usually musicians, when they do their composition, they will be entering into contract with record company or film company. So how do they enter into these contracts? Do they have any protection of the law? That was our second survey question. So you could see on the slide, on the screen, our second question is there any law governing unfair contract? And we have different definitions of unfair contract, as you will see in my subsequent elaboration. And then number 3 and number 4, these are about protection for creators. And in particular for this study, the creators, we are talking about musicians, composers. So question number 3, we would like to find out whether under the law of these member territories, creators will have a right to what we call equitable or fair remuneration. And question number 4, we also want to find out whether these creators or musicians will be allowed to revoke or to cancel the copyright buyout contracts, or whether the contracts will be terminated automatically if something happens. And then question number 5, this is a more general copyright law question, and that is about who owns copyright in 2 particular types of work. And they are what we call employees' works and commissioned works. And we will talk about the differences again when we come to the survey results. Question number 6, in particular, we want to find out whether governments in different member territories, they have any particular legal provisions to govern government copyright. In other words, whether there is any law in the member territory saying who owns the copyright if it is the government that is in charge of the copyright work. Finally, our last question is whether there is any public campaign or education campaign in the member territories to increase public awareness of copyright issues more generally. And I'm going to share the survey results from the 8 territories that we investigated in phase 1 of this comparative study. Question number 1, it's about moral rights. As I said, moral rights are different from copyright. So I know that this symposium will be joined by different members of the public, including musicians or including lawyers. So for the benefit of those who might not have the legal background, I'm going to very briefly talk about the meaning of copyright and moral rights. As you can see on the screen, copyright, from the word copy, it is about a right to copy or to communicate the work to the public. And it's a bundle of rights, it's a collection of rights. There are 7, 8, or 9 different types of rights in different jurisdictions. And together, we call these rights economic rights. Why they are called economic rights? Because when you grant the right to copy to, say, a third party, you can actually charge royalty, or you can ask for a lump sum. So that is why it is how you can generate income. So we call this an economic right. And these rights, you can actually give away or assign to other people if you want, of course, in return for money. And here, I want to distinguish between 2 types of remuneration. On the one hand, we have royalties. Royalties would be money that you can receive on a regular basis when your work is being played by the person paying for the right. The more times your song is being played, the more royalties you will receive. So this is what we call royalties. On the other hand, we have the buyout practice or the buyout situation in which the creator will only receive one lump sum and then sell all his rights to the film or the video game producer once and for all. No more royalties and cannot use the work afterwards. So this is the copyright side. Now, how about moral rights then? Moral rights are not really about making money or generating income. As you can see, the most important moral rights I have put down here would be the right to be identified as the author. I think this is the most important right to any creator. You want people to acknowledge your work. Or another type of moral right would be the right to object to derogatory treatment. That means if someone is using your work with modifications that you are not happy with, then you can say no. That is called objection to derogatory treatment. And I call these rights your personal rights because it is more about you as a person, as an author. So these are also called the author's rights. And that is why, because it is related to you as a person or as an author. So usually you cannot give up or waive these rights. That means these rights will be yours for as long as you wish. Unlike copyright, you can give it away to a third party easily. And so according to our first phase of the study, we surveyed these 8 territories. We surprisingly find that 7 of them say that the authors, the creators, cannot give up their moral rights, as I said, because you are the author and you enjoy the moral right forever, even if you have given away your copyright. I said, interestingly and surprisingly, it is in Hong Kong, the only place where you can actually give up. You don't want your moral rights, that would be fine. Because Hong Kong law, copyright law, we actually allow authors to give up or to waive their moral rights if they don't want to keep their moral rights anymore. But here, because we are doing a comparative study, so I will not bother you with the details of the legislation, because the details can be found in my report on phase 1 of the study. So maybe for the sake of simplicity, I will just give you this overview so that you can see all the places except for Hong Kong actually take moral rights very seriously, and they cannot be given up. If I may move on to the next question, which is about unfair contract law. And I said before, there are 2 types of unfair contract. The first type would be unfair formation of contract. And that means, as you can see from the picture on the left, if someone is holding a gun, forcing you to enter into a contract, that means there is no genuine consent. Then you can say, no, this is not my contract. And then this contract will be terminated afterwards because this is not my wish. This is the first type of unfair contract. Another kind of unfairness would be when the contract terms, the clauses are unfair to you as a contracting party. So in other words, there are 2 contracting parties, but because you are the weaker party, you don't have the bargaining power, and therefore, there are some contract terms that are unfair to you. So we, in the survey, wanted to find out whether there is any contract law in the 8 territories about these 2 types of unfair contract. And the result is, for the first type, that means unfair formation of contract, all 8 places would have some legislation preventing unfair formation of contract. For unfair contract terms, that means the second situation. As you can see on the screen, not every place has the legislation to deal with this. For example, Australia, they do have the law. Japan has also amended its civil code recently. And Thailand also has some legislation about standard form contract. So again, for the sake of simplicity, I will not bother you with the details of their legislation because these are already included in my report. Number 3, I think this is really the key question today. It is about whether the creator, that is the musician in this case, has a right to equitable or fair remuneration. In other words, I may have done something that is so brilliant that I may be entitled to additional remuneration. And interestingly, of the 8 territories that we surveyed, only Macau has legislation about fair remuneration. And I have included their legislation in the PowerPoint. And there are 2 provisions, 2 articles in their legislation in Macau. This is the first one. Article 12, subparagraph 4 in Macau. You can see I have already underlined the keywords for you. And here it says, the creator, that means the musician, shall be entitled to, you can see I have underlined, special remuneration in addition to his agreed remuneration. In other words, the 2 contracting parties, they already agree on a sum of money. But because of the special circumstances of the case, the creator shall be entitled to additional special remuneration. So what are the circumstances then? They are paragraph A and paragraph B. So paragraph A here is that the creation has gone beyond the limits of your duty. So in other words, maybe I just asked you to compose a very simple song, but then it turns out that your song is more than simple. I mean, it is a big hit. It has generated a lot of income, which is out of our expectation. So that would be clearly gone beyond the limits of what I expect of you. And paragraph B, where uses are made of the work or benefits are derived from it that were not included in the original negotiation. That means it is something beyond our expectation. Then in these two circumstances, the creator will be entitled to special remuneration in addition to his agreed remuneration. There is another paragraph in their law, paragraph or Article 36, which says that if after transferring the economic rights in the work for a sum of money, the creator suffer a grave economic prejudice as a result of disproportion between the income and the receipts earned by the beneficiary, that is the person getting the copyright, then the creator can demand additional compensation. So after the first phase of the study, we believe that this is something we would recommend, as you will see towards the end of my presentation. This is one of my 5 recommendations to all the member states, for all the member territories for consideration. Question number 4, it's about the duration of the contract. So can you actually terminate or revoke a contract? Of course, a contract is a contract. Usually, whether you can terminate it would generally depends on parties' agreement. In other words, we want to advise all the creators, all the composers out there, please check your contract and make sure that you know what you can do or cannot do under your contract. If the contract says, yes, you can terminate or you can revoke it, then of course you can do this. And after terminating, all the rights, all the copyright will go back to you as the creator. So that is the first thing you have to do to check your contract. But in addition to the contract, we also have the copyright law to help you out. That is why at the bottom of this page, you can see I said in some jurisdictions, their copyright law actually specifies the circumstances under which a copyright buyout contract may be revoked. So what are these circumstances then? This is a summary of the 8 territories that we have surveyed. You can see all 8 of them would agree that if the parties say you can, then of course you can. That's why I put down depends on the parties' agreement for all 8 places. But then there are some other jurisdictions that have additional provisions. For example, there are 2 types. It is about the duration and also it is about whether there is exploitation. Now, maybe we can start with the duration. As you can see, I have highlighted in red color. In Indonesia, for example, if the buyout contract is for an unlimited period, then after 25 years, it will end automatically. In other words, we believe that 25 years would be long enough. And so after that, the creator will be free to use the copyright in any way he or she likes. Likewise, if we move to Macau, you can see Macau has a similar provision, also 25 years. Further down towards the bottom, you can see for Thailand, it will be 10 years. So these are the 3 places that say, if we wait for 10 years or 25 years and the contract is no longer useful, then it will be terminated automatically. Another situation I have highlighted in green color would be, let's say in Japan, when the creator finds that there is no exploitation of the copyright work. In other words, I have sold my copyright to you, but you have not done anything. I mean, the producer, the film producer, or the game producer, they have not done anything. They have not used my work, my musical work, for any of their production. So that is what we call non-exploitation of the publication rights. Then, as the creator, as the musician, I can terminate this contract. This is also the case in South Korea. You can see they have a similar provision in green color. And also in Macau, they said here, the creator can terminate a contract if he or she suffers from considerable prejudice. So again, that means I have given you my copyright work, but you do not use it to generate any income. So I can give it, you should give it back to me so that I can use it for more beneficial purpose. And then question number 5, we want to see whether there is any legal provision about employee and commissioned work. Employee's work means that it is created by an employee, whereas commissioned work means it is created by a freelancer. We know the difference. A freelancer is not on the payroll, is not an employee. So it is only doing a job on a case-by-case basis. So in these two cases, who own the copyright then? In the 8 territories, we find that there are some simple laws and some are more complicated. For example, you can see that in more than half of the places, the employer would be the owner of the copyright if it is done by an employee. I have highlighted them in green. Those are the provisions in favor of employers. But there are some exceptions. For example, you can see in Australia, Indonesia, and Thailand, they actually give the copyright to the employee if the work is done by the employee. On the right-hand side, for commissioned work, and you can see we have different legal provisions in different places. For example, in Australia, you can see it depends on the types of the work. If they are photographs or painting, engraving, sound recording, then the person paying for the work will have the copyright. But other cases, then it will be the creator. And also in Indonesia, Japan, South Korea, it would be the creator who gets the copyright. Whereas in Hong Kong, it will be the person that is specified in the contract. So it can be the person paying or the creator. Really depends on what you say in your contract. Question number 6, we wanted to know whether there is any law governing the ownership of government copyright. And interestingly, we find that half, that means 4 of them, actually has specific law about government copyright. And they are Australia, Hong Kong, Thailand, and Vietnam. And the other 4, they don't really have specific provisions. That means the general law would apply. Final and also another important question is, we want to find out whether there is any public campaign or education program in these 8 places. And we are very, very happy to see that in Australia, Indonesia, Macau, Thailand, Vietnam, they do have copyright seminars, regular meetings to educate the public. In Japan, of course, we have JASRAC, and they are doing this online seminar, and they are doing other things to promote awareness of copyright. South Korea, also, they have COMCA doing a lot of education now. And I highlighted the only place I'm not sure about is actually Hong Kong, because here I have put down our intellectual property department. I would hope that they have done more. And so that is why after this presentation, I would be talking to our intellectual property department in Hong Kong to see whether they will do any public campaign to educate the public about copyright, in particular copyright buyout. So a summary of the 5 recommendations would be here on the screen. Number 1, we hope we can all regulate unfair terms in copyright buyout contracts. So this is about what you put into your contract. Number 2, we hope we can all grant creators the right to equitable remuneration, fair remuneration. Number 3, we hope there will be an option for the creator to terminate the contract if there is non-exploitation. That means no public use of the work. Number 4, we hope there will be fair, transparent negotiation between employer and employee, or in the case of commissioned works. Finally, we hope all the territories can organize public campaigns to raise awareness of copyright issues. In particular, as I said earlier, for equitable remuneration, we can find very helpful guidance from, the first one is Macau's example. I have already talked about their 2 articles. Another good example or guidance would be in Europe. They have the Copyright Directive, Articles 18 to 20. And finally, The way forward, we have already started phase 2 of this comparative study, and we have distributed questionnaires to 7 other territories, including Cambodia, China, India, Malaysia, Singapore, Taiwan, and the Philippines. And we have also done a brochure to actually summarize copyright buyout in simple terms for everyone. And very soon, we will be following up on the questionnaire with these 7 member territories, and we will do a report on phase 2. So hopefully, we will be working together and raise awareness of copyright buyout issues in the Asia-Pacific region. That is my presentation. Thank you very much.
Thank you very much, Professor Lee. It's a very clear and informative presentation of the comparative study and with 5 recommendations. And also it's on time. So I think we have questions, but I will see the questions during the break. So I propose a 10 minutes break. And Professor Lee, would you turn off your camera during the break? So 10 minutes break, and please come back in 10 minutes. Thank you. Welcome back to the symposium. Thank you. Now we start the panel discussion. I ask Mr. Gadi Oron to join. He is Director General of CISAC. Gadi, would you turn on your camera? We have received questions to Professor Lee. We will discuss these questions all together after the final part of the panel discussion. Gadi, Alice, would you turn on your camera? Thank you. I see you. Okay, this panel. Mr. Tokura unfortunately cannot attend this panel, so I will moderate the discussion. First, I introduce Mr. Gadi Oron. He's Director General of CISAC, and he's a lawyer in the entertainment and intellectual property field. So first, I want to discuss or introduce APMA's buyout campaign. APMA was formed in 2016 as a partner alliance of SIAM, that's International Council of Music Authors, to promote the music creators' rights. And as Mr. Tokura mentions now, from 21 countries and regions in the Asia Pacific, now they are affiliated music creators. APMA has identified copyright buyouts as one of the key challenges for music creators, adapting the Seoul Declaration 2017 and the Jakarta Statement in 2018 to draw attention to unfair practices in the form of copyright buyouts and to call on stakeholders to address and fix the problem. And APMA commissioned Professor Lee to conduct a buyout study in 2018, and the result of which you just saw the presentation for the study phase 1. And APMA is now preparing a brochure providing music creators with basic information about their rights and copyright buyouts. I want to show the brochure now. As you see, it's a little bit small, but it's a concise, handy brochure. It's a very simple questions. You might not see. The questions will be, what is copyright? Who owns copyright? What is copyright buyout? And the checklist. And the final message is, at the end of the day, you music creators are free to decide whether or not to sign the agreement. So this is the buyout brochure. APMA is going to print the brochure in Asian languages such as Chinese, Japanese, Korean, Thai, and so on. And of course, we will have the digital brochure you can find soon at the APMA website. Okay, that's APMA brochure is a part of public awareness campaign. So, Mr. Gadi Oron, I understand that copyright buyouts are one of CISAC's main concern right now. And the CISAC has initiated an educational campaign on this subject. So can you tell us more about this, please?
Yes, of course. So indeed, buyouts is one of our top priorities internationally. And as was mentioned earlier, and in line also with what APMA are doing, what we want as an international organization is to help creators understand this issue and understand the impact that buyout contracts can have or could have on their careers. It's important to remember that when you look at this issue of buyouts, it's something that affects creators all around the world. It affects creators everywhere. It's a global problem, and we see it from an international perspective. We see it everywhere. So in a presentation earlier, Professor Lee talked about the situation in Asian countries and in the Asia-Pacific region. But it's important to remember that buyouts exist also in South America. Buyout contracts are becoming more and more popular in Europe. They, of course, exist in the United States. They exist in many other places. And it's also important to remember that they also affect different types of creators or creators who are active in different types of repertoire, whether it is music, whether it is creators of audiovisual works, whether we are talking about creators who are involved in the production and creation of video games. All of these creators find themselves in the same situation. You know, they have in a buyout scenario, they have a lack of choice. They don't really have a choice. They don't have a negotiating power, usually, to negotiate something better for them. All of them lack information about what these contracts actually mean for them, what they could mean for their careers. And, you know, all of these creators are facing the same potential harm to their future careers. So I mean, we talked a lot about the background. We talked a lot about the legal, in previous presentations, about the legal aspect. I would like to invite you to imagine this. Think about a young creator, creators who are just starting their careers now. They dream of becoming famous. They dream of writing that one song that will break their career internationally, that will make them successful, that will make them rich, that will make them famous. You know, most creators in that situation, when they start their career, they work day and night, writing new songs or creating other forms of creative works. And at that stage of their career, they will accept anything that is offered to them. They will take anything that they receive just to start working, just to start, you know, becoming more popular, to gain more fans, and of course, to make some money so that they can make a living from their creation. Because as we know, when creators start their career, many times they do something else to support themselves financially, but they all have this dream of becoming successful, becoming famous, and living from their creation, benefiting from it financially. So while they have these dreams and while they work hard, they receive an offer to write a song for, let's say, a TV series. And they already picture, they have this image in their minds. They will become successful. They will write this song that will make this series will become a global hit, and the song will become also a global hit. It will be played on the radio. It will be streamed online in different platforms all around the world. They can already see how this will break their careers and how it's going to change their lives. Well, none of this will happen if they've transferred all their rights. If they sign a buyout contract, whether they understand it or not, they will not benefit from the success of the song they wrote. The song will become successful, for sure. The TV series may become a hit. The song may become very successful, but the creator will see that from a distance and they will not benefit from it financially. They will see the song played on the radio. They will see how much it is streamed, but it's very likely that they will see no benefit from that at all. So as we heard earlier, there can even be situations where the creator themselves, himself or herself, will not be able to perform their own song in the case of some draconian contracts that forced the creators to transfer all their rights. So what we want to do as CISAC, as an international organization that really has the benefit of the creators in mind, is to help them understand what these contracts are, what could be the impact of these agreements, what could be the consequences of the creator signing such buyout contracts. We don't want to tell creators not to sign these agreements. We don't want to tell them you should never enter into buyout contracts. That's not where we are coming from. What we want to do is to equip them, equip the creators, or I would say arm the creators with all of the information that they need in order to make an informed decision. Because this is a decision that could affect their career. It could affect their career in the future. We want the creators to understand that when they give away their rights in a contract, it could mean many things. It could mean a loss of control over their works. It could mean a loss of the ability to earn an income from these songs or other creative works. And it could possibly mean that they will see the film or the TV program that they wrote the song for becoming extremely successful, and they will not be able to share in any way in this success. So we want creators to have this knowledge. We want them to have the information so that they can make their own independent, their own informed decision. And that's one of the reasons, that's actually the main reason that we launched the campaign that you've mentioned, Your Music, Your Future International. I will try to share my screen and show you how the website looks like. This is the front of, or the main page on the website. What we did is we at CISAC partnered with a movement that actually started in the US. It was a movement that had the goal of providing this information to creators. It was actually an initiative of creators, individual creators, who wanted to give this information to other creators. And what we did at CISAC is to take this initiative to the international level. So now we have, with Your Music, Your Future, a global education resource, something that creators can use. It's totally dedicated to buyouts. The whole initiative is an extremely important initiative. I think it's also a wonderful initiative. I said it started in the US. It was, I need to give credit to an American creator, Joel Beckerman. He was the guy who started this project, this idea, together with a group of other composers. They launched the first Your Music, Your Future platform, which was initially primarily for US creators. And today it has more than 15,000 creators who signed up for this initiative. And really, as I said, it's about explaining from creators to creators what buyouts mean, how buyouts differ from receiving royalties, what are the types of clauses that you can be offered in a buyout contract, information about the different laws that apply around the world. Again, the goal here is to become an education campaign. It's not an advocacy campaign. It's not targeted at governments. It's targeted at the creators themselves, because we want the creators to understand their options. We want them to know, what does it mean to sign a buyout contract, as opposed to what does it mean to receive regular royalties for the future. And the people behind this project are creators themselves. As I said, it started by creators. We just took it internationally. You can find on the website different quotes from creators, and it's a global movement now. And this is why it was so important for us at CISAC to be a part of this, because it's an international problem and something that international creators all around the world need to be aware of. maybe a final thing on this, on the international aspect of this website and of this campaign, is that it is now in English, but we are working on preparing other versions that will be tailored to different markets. So now we are preparing a version in French, in Spanish, in Portuguese, even in Finnish. There will be a website very soon, and hopefully maybe one day also in Japanese and other languages.
Okay, thank you, Gadi. Alice, CISAC, as you see, that CISAC is conducting an educational campaign, and you are an IP education expert. I saw very lovely animation series you put up. Do you have any comments on this authors' rights campaign?
Thank you very much. Actually, I like your Music, Your Future campaign very much because I could see many creators, many composers actually sharing their quotes. And I think it's really important to get not just these composers. Of course, it's great to have composers sharing their views and their experience. I think to bring it forward, maybe we need to involve more different members of the public, including, I would say, on the one hand, the young people, because as Mr. Gadi Oron has said, we're looking at the young creators, the young composers. So I'm thinking maybe we could actually extend this program to, say, primary or secondary school students, because they might be already composing their own music. So if they know when they're still young that these are the options that they have, then, because nowadays, I mean, even a primary school student might be already having his or her own YouTube channel. They might be composing.
Oh.
So, right? So yeah. I think this is what I would like, what I have in mind right now. So I have already got, actually in Hong Kong, I have already started an intellectual property ambassador program, because I invited my students to go to share their knowledge, their copyright knowledge with secondary school students and teachers. So I think copyright buyout will be the next topic that I would like to share with these students and teachers, I guess.
Very interesting. Yeah. Okay. Well, music creator needs to be well educated, well informed of his or her rights to make an educated decision when approached with a buyout deal offer. But for a music creator in need, it will be a little bit difficult to negotiate a fair deal with a big company. How can a music creator secure fair terms for their labor? Gadi, I think that CISAC has produced a buyout guideline. Can you talk about that?
Yes, of course. So indeed, as you said, there's an education issue and there's an information gap when it comes to buyouts. And CISAC indeed worked on guidelines on this issue, because the first thing we need to remember is that the contracts themselves can be different in different countries. The practice of buyouts can take different forms and different shapes. And even though the basic idea is the same, a complete transfer of rights, the legal systems around the world are different. And because of that, the contracts can also be different, which means that the way to challenge these contracts, the arguments against such contracts, are not the same everywhere. There are some common elements, and I think that perhaps it will be useful. We've prepared a slide that shows an example, because we've been talking a lot about the buyout contracts. We haven't actually shown how they look like, how the provisions look like. So let me share an example that, to illustrate this. So what you see here is a clause taken from a contract that includes buyouts, a buyout clause or buyout provision. And what you can see is that it's very broad. And that's something that we find in most buyout provisions or buyout agreements. They are very broad. They cover the whole world. They usually apply to all of the rights of the creator. So they cover all the rights that the creator has. They usually cover the period of the life of the creator plus 70 years after his or her death, which is the term corresponding to the term of copyright in most countries. And yes, and all of these contracts basically say that in exchange for a one-off payment, the creator gives away all of the rights for the whole world for the whole duration of copyright. And because the copyright laws are different in different countries, you need to find different solutions or different approaches to dealing with these contracts. And these different solutions will depend on which country we are talking about. And it's a very complex issue, and that's why we started to look at it internationally, and we took the initiative to investigate what's happening around the world. And we've produced later the guidelines. So as I guess many people on this watching us will know, CISAC is an international organization that brings all of the author societies of the world together. And all of these societies operate in more than 120 countries. So we reached out to all of them so that then we can go back to them and help them understand how they can help their creators who maybe signed a buyout contract without even understanding what they signed. And we wanted to help the societies, and through the societies help the creators understand what could be the arguments against such contracts. So if we use some examples, and it was mentioned earlier, the concept of work made for hire, this is something that comes from the US system, the US copyright law. And it basically means that the employer or the producer of the work is considered the author, and therefore is considered the first owner of copyright. And indeed, we see many buyout contracts that basically apply this concept, and they say that the contract itself will apply US law. This will be the law that governs the contract. And the contracts include the doctrine of work made for hire, which is an American or a US copyright law doctrine. But when the creator is not American and is not a resident of the US, and the production is not in the US, and the film or the TV series that we're talking about, let's say, are produced in Europe, then why should we accept that the law of California or the law of the US should apply to this type of relationship? And this is the sort of questions that we struggled with, and this is why we ended up investigating this and looking at the different situation around the world. And you do find that in many places you have much stronger protection that can be used to protect the interests of creators. So for example, in Europe, we find much stronger protection for creators. We find them in individual countries. We find them under rules that apply throughout the US by virtue of the EU directives. And the EU, the European directives, talk about the right of authors to have fair payment and proportional remuneration. Fair payment, proportional remuneration are things that can challenge buyouts. There are individual countries in Europe, Germany, Netherlands, a few others, that expressly prohibit buyout contracts. There are other countries that require under their law that there will be a fair remuneration, which is proportional to the income that is generated from the work. In other words, a payment to the creator that is in line with how much the work that he created actually generated commercially. And this is the situation, for example, in France, in Italy, in Spain, in others. But if we turn to the rules that apply throughout Europe as part of the EU legislation, we have a fairly new directive in Europe, the Directive on Copyright in the Digital Single Market. I'm sure many people who are watching this have heard about this directive. It's a very important directive. It talks about one of the things there that you find, it's in Article 18. It is the right of creators to appropriate and proportionate remuneration when they license their rights. When they give away their rights, they are entitled to appropriate and proportionate remuneration. There's also a provision there that says that if there was a lump sum payment, it could constitute something which is a proportional remuneration, but this should not be the rule. In other words, in Europe, it is clearly stated that buyouts should not be the common practice. It should be the exception. There are many other rules that talk about the specifics of this issue, but I would like to mention some other things. And in this important European directive, we find what we refer to as the transparency triangle. Transparency triangle, to say that it's a combination of rules that are there to protect the interests of creators. So one of them, we call it the bestseller clause. And what this clause means, you find it in Article 20 of this directive, is that if the work becomes very successful in the market, the author has the right to demand a renegotiation of the contract. Or in other words, it's a contract readjustment. The author can go and say, well, you know, we did not anticipate that commercial success and that amount of money generated by the work. I would like my contract to be renegotiated. And that could be used to challenge buyouts. Something else which is very relevant is all of the reporting obligations, the transparency that is imposed by this directive, so that the creators have a right to receive regular reports about how the work was used. There's also a dispute resolution mechanism that representative organizations can utilize and can launch. That's very important because, as we know, in most cases, the individual authors do not have a lot of power. And in fact, they are afraid of retaliation, or they are afraid of being blacklisted by the producers of creative works. And here, organizations that represent them can launch these dispute resolution mechanisms. And all of these things are mandatory. That's very important to remember. And these are the things that we looked at as part of our guidelines for societies. The producers cannot circumvent all of these rules by saying, for example, that the contract is subject to US law. It's just not going to be valid. In fact, there's also some rights for the authors to revoke agreements. For example, when the work was not used, they can try and revoke the agreement. So all of these things can be used to help creators to get a better share, and to prevent situations where the producers of the work deny the creators remuneration through this one-off payment that they've received in the beginning. Another point that I would like to mention in the context of the guidelines that we've produced is that sometimes, you know, when creators join an author society like JASRAC and like many of the other societies around the world, they already transfer their rights. They give the rights, or they mandate the society to give they give the rights to the society. And in those cases, when a producer arrives later and offers a contract of buyout, it can actually conflict with a transfer that already took place, or a mandate that was already given by the creator. So yes, I guess the question is, when a creator already signed the buyout contract, what can be done? And this is really why we wanted to produce these guidelines and to inform our societies that there are many things that they can do. Perhaps if there's, if US law applies and there's a reason to apply US law, then perhaps there's not much that can be done. But if there's no reason to apply the copyright law of the US to the relationship between the author and the producer, then you can rely on all of these rules that you find in European laws to challenge, and you know, the rules that do not permit this type of contractual agreement, and really to insist that the creator has proportionate remuneration, fair remuneration. There's lots of arguments that can be used. There's no one-size solution this situation. It's a very complex issue. As I said, the laws differ around the world, but what we really wanted to do with the guidelines is to give the societies I would say, the arsenal of legal arguments that they can use to help creators, and this complements the awareness raising campaign that is directed more at the creators themselves.
Thank you, Gadi. Now I'd like to read some of the questions we have received and ask two speakers' views. First, this is a question from Europe, I guess. In Europe, members of the CMOs are not allowed to agree to full buyouts because of their exclusive membership agreements with CMOs. Is this different in the Asia Pacific? Professor Lee, have you, this kind of issue is included in your survey?
Exclusive. Could
Right.
you please repeat the part about exclusive?
It's the society, its members mandates their rights on an exclusive basis. For example, JASRAC members make a membership contract, and they entrust all rights with us on an exclusive basis. But of course, we have some exceptions. And I think most Asian societies have the similar mandate agreement with their members. And here's the question: if a society member mandate the rights on an exclusive basis, why buyout deals can be allowed?
Interestingly, we did not specifically ask whether all the CMOs, they are doing this, mandating this. So it may vary from one territory to another then. I think that is a very good question. Maybe we should include this question in our survey now. Thank you very much.
Of course, it's, I think it's a CMO representation. And of course, they have some issues with members, especially now non-exclusive mandates, including multi-territorial digital licensing. We see many territories, but I think it's one issue. Two could be a CMO regulation. Here's another question. Are there ways in which creators themselves can increase their ability to negotiate if you face with the buyout deal? Gadi, do you have any comment on this?
Yes, well, I think that this goes back to what we've discussed earlier about, first of all, having the knowledge, the understanding of what it actually means. And when a creator knows what he should be looking out for and what the contract could mean, and he knows the fact that they have these rights and that they are the basis for the future royalties income, then they can use it in negotiations. So one part of it is the education and awareness. And the other part, which goes more into the ability of societies to help, which is why we informed societies about all of the potential arguments, the legal arguments. We don't want creators to become lawyers. We want creators to be creators and focus on their creation, but they should know that there are many legal arguments that can be used. And as I said in the example, if there's no relationship at all to the US, then a creator should know that there's no reason to apply the law of the US to the contract. And that's something that can be negotiated. And we know that many creators are facing a situation of imbalance in the negotiation power. Usually the production company is very strong and the creators are afraid that they will lose the contract that is offered to them, or they're afraid that they will be somehow blacklisted. But at the same time, I think that when the creators are aware of their rights and they are strong in the negotiations, and they also know that they have the societies backing them and supporting them, I think that this could make the position much stronger.
Mm-hmm. Thank you, Gadi. Another question, this was raised during Professor Lee's presentation. Is the music industry in general respecting rights and providing adequate remuneration? I think the question is asking in the Asia Pacific region. Professor Lee, do you have any response to this?
Whether the music industry in general respecting their rights to receive remuneration?
Yes, I think so.
Well, from my observation in Hong Kong, for example, I think their rights are being respected generally. I do think so. But I heard from colleagues that in some other places, for example, Thailand, let's say, there might be less respect. So that's why I don't think we can say in general for all Asia Pacific, because we might have different practices in different places. And so that is why I want to propose one thing, and that is we could actually use this Your Music, Your Future campaign to actually talk to not just members of the public, but also governmental bodies. Because I think it would help if the government or government-related bodies can actually take the initiative in setting an example. In other words, if a government body is hiring a musician, let's say, to do something for government-related productions, and they set a very good example of respecting the creators' rights, then I think the whole industry would be following. It would be easier, I mean, for the musicians to negotiate on fair basis.
Another question is here is, it seems the copyright law in Macau seems good for the protection of creators. Why that? Is this based on the background?
Yes, yes. That is because it is, I believe, based on their Portuguese background. And so that is why their laws are very different from the rest of the region that I have been surveying. So that is why you remember at the end of my presentation, I actually said that we could have very good guidance from Macau on the one hand and the EU directive on the other hand. And that is because the Macau example actually is rooted in Europe. It's because of their origin. So I think that is the reason why they have very unique provisions in the whole Asia Pacific region.
Okay, thank you. And Gadi, that's European Copyright Directive need to be introduced in the member state domestic law by June this year?
Yes, yes. Usually there's a transition period, and once the directive is adopted, the European Union member states have a certain period of time to adjust their laws to meet the requirements of the directive, and they are now in the process of doing it. Of course, I think that what the world and Europe has gone through in the last year will probably delay that because there were other priorities. But yes, countries are working on adopting their laws to the elements and the requirements of the European Directive.
Mm-hmm. Okay. Here is another question that's similar, but I read, should CMOs establish institutions to advise or mentor young creators about music contracts? We have discussed, Professor Lee suggested even very young students need to be educated. But do you have anything to add?
Well, I know from our work with many societies like JASRAC and like many others in Asia and in other regions that many of them are doing this through different initiatives. So there's different workshops, different projects to help young creators get the knowledge and understand about their rights, what they mean, why they are so important to their career. And many of our societies do it in their own country, the country in which they operate. But of course, we do a lot of projects like that internationally through CISAC, Your Music, Your Future International. The website is one of these platforms that we did at an international level to help creators all around the world. There's CISAC also has creators councils. SIAM is the International Council of Music Creators, and APMA is the Asia Pacific Music Creators Alliance, which is the regional alliance of SIAM. All of these entities operate internationally and regionally to bring the information and to make it accessible to the creators. So definitely there's a lot of these activities happening.
Mm-hmm. Okay. Gadi, is there any similar activity in Latin America or maybe Africa?
Yes, indeed. So in Latin America, as I mentioned very briefly, buyouts are also a major concern. And there was an effort there by Latin American societies to address this issue and again, learn what is happening in the different countries and how it can be addressed. The most recent step in that was the commissioning of a legal opinion, just like Professor Lee did for the Asia Pacific region. We are now doing the same in Latin America, again, to build the basis of knowledge about the problem and how it can be addressed.
Okay. I asked my colleague, do we have any more questions? No? Okay. So we have covered most questions. And I like to hear any final comments. And Professor Lee, you have made the recommendations in your report, and you are conducting the phase 2 study for more territories in the region. Do you have anything to emphasize or expectation to the second phase study?
May I share my PowerPoints again?
Sure.
Maybe? So this is the final, almost the end of my presentation about the recommendations. As you can see here, the recommendations cover different things. For example, the first one is about contract terms. And then number 2 is about remuneration. Number 3 is about the right to terminate a contract in case of non-exploitation. Number 4 is about contract again. It's about whether an employee or a creator can negotiate with the employer or with the commissioning party. And finally, it's about public campaigns. So if you ask what we should be emphasizing, of course, I think we should always start with the creators, as Mr. Gadi Oron has already pointed out or emphasized before. We need to empower the creators with the knowledge that they need. I think this is step number 1. They get the knowledge. They know what options they have or what the law is or what does it mean? I mean, a buyout as opposed to receiving a royalty. So this is basic knowledge. And if they have this basic knowledge, then they can talk about fair remuneration. They can talk about the right to revoke contract in case of non-exploitation. But once again, I would say even with such knowledge, which is essential, it doesn't mean we can change the buyout practice unless and until we have somebody with the bargaining power to set a good example. And that is why I emphasize on the last point, the public campaign. In other words, I hope those who have the power could actually come forward and share the knowledge with the general public and set a good example. Because without a good example, I don't think the employer or the commissioning party would be willing to actually give more rights or more remuneration to the creators, even though we know it is something that they should do. So this is my personal view in promoting all of this. We should bear in mind that knowledge is really, really the first thing. But with the knowledge, we should also come a good example, preferably from someone or some organization that can set a good example for the entire industry. I think that is how we can change the life of all these young musicians. So this is my personal view. I therefore look forward to working with different parties and different partners, all the CMOs or CISAC in this kind of education public campaign, so that we could actually make more people aware of the importance of buyout and the significance of the changes that we can make.
Thank you very much indeed. I look forward to the results of the phase 2 study.
Thank you.
Gadi, do you have any final remark?
Well, maybe just to make a link with what Professor Lee just said, I think that we need to remember that in buyouts, like in any other challenges that we have in the creative industries, the creators themselves, even though they are probably the most important part of the creative industries, because there will be no music industry, no film industry, no TV without the creators, they've always been at a very weak position, at an inferior position. And the only way to change that, the only way to empower them, to help them be stronger in negotiations, is to have strong laws, to have a good, legal framework. And what we saw in Europe is definitely the right way to go. We need more and more countries to have laws that will protect the interests of the creators and make sure that they cannot be forced to give away their rights to others and be left with no ability to make a living from their works. So we need the legislation. We need to empower creators through the education that we talked about, so that they know what their rights are. And usually there's a big gap there. And we need strong bodies to back creators and to be with them, to support them. And that's the role that CMOs, societies like JASRAC and many others are playing, to bring the knowledge and to also be there to assist the creators if they are facing situations where they are offered contracts that they know would put them at a disadvantage and risk their future careers.
Thank you. Creators first, we say. Thank you for joining Asia Buyout Symposium. I'd like to thank all speakers and Professor Alice Lee, Gadi Oron, for their great contributions today. I think the discussions today will be very useful to music creators and stakeholders for their career making and the policy making on the copyright buyout issue. So I'm closing the symposium. Thank you again. ありがとうございました。
Thank you very much.
Thank you.
Thank you. Thanks.
Thank you.